Hello and good afternoon to all my students. I hope all of you are doing well. So in my last video, I talked about second appeals, and in this video, I'll talk about appeals from orders, which is our next topic in Civil Procedure Code. So let's just start with it. Relevant provisions with regard to appeals from orders are section 104 and order 43 of Civil Procedure Code. So section 104 to 108 deals with appeals from orders, and if you talk about section 104 and order 43 rule 1 specifically, it provides a list of orders which are appealable. So we all know that there is a difference between order and decree. So what is order? Order has been defined under section 2 clause 14, and it says that order is a formal expression of any decision of a civil court which is not a decree. So from this we can understand that there is a similarity between order and decree, and the similarity is that both order and decree are decision of court. Now what is the difference between order and decree? So decree is passed in a suit which commences on filing of a plaint. We have already studied that for decree, filing of suit is necessary, and what is suit? Suit is a proceeding which is instituted by presentation of a plaint. Now when we talk about order, order may originate from a suit by presentation of a plaint also, or it may arise from a proceeding that has commenced by filing of a petition or an application also. So this is first point of difference between order and decree. What is the next difference? Next is that decree is conclusive determination of the rights of the parties, but when we talk about order, it is not so. Like if you take the example of interlocutory orders or interim orders, then orders do not generally conclusively determine the rights of the parties. Now we have studied that every decree is appealable, unless of course otherwise provided. But as far as orders are concerned, not all orders are appealable. Only the orders that are provided under section 104 and order 43 rule 1 are appealable. Now when we talk about decree, a second appeal also lies against decree, but no second appeal lies against appealable orders. So with regard to second appeal against orders, you can also refer to section 104 clause 2, which says that no appeal shall lie from any order which has been made in an appeal. Okay, so we have gotten an idea about what are appealable orders. Now let's just take few examples of orders which are non-appealable. Now first example is if the court has passed an order wherein it has held that it has jurisdiction to try a suit, such an order is non-appealable. Next is if the court has passed an order whereby it has appointed a commission to ascertain mesne profit in a particular case, that order is also non-appealable. So now in order to understand better about appealable orders, we will quickly refer to section 104 clause 1. Let's just move. So section 104 clause 1 provides for 5 types of orders that are appealable. Okay, so first is an order of cost under section 35 capital A. When you are going to refer to section 35 capital A, you will find that it talks about compensatory cost for false or vexatious claims or defenses. Now if such an order has been passed by a court, the aggrieved party can file an appeal against such order as is provided under section 104 clause 1. Okay, but then the proviso to section 104 clause 1 limits appeal against such order which has been passed under section 35 capital A to 2 grounds. First is that you can challenge such order by saying that no order could have been made, and second by saying that order for a lesser amount ought to have been made. Right? Other than this, you cannot challenge the order that has been passed under section 35 capital A. Next is if under section 91 which talks about suit against public nuisance, and when you're going to read that section, you will find that if 2 or more persons wants to file a suit against public nuisance, then they must take the leave of the court. Now if the court has refused such leave to institute a suit against public nuisance, then against such order also an appeal is going to lie. Similarly, if an order has been passed by court wherein it has refused the leave to institute a suit in case of breach of trust under section 92, in that case also such order will be appealable. Next is if the court has ordered compensation to a particular to a party in favor of a party uh, against another party which has obtained arrest, attachment or injunction on insufficient grounds. Now in this case also the aggrieved party, that is the party against whom such an order has been passed, can definitely go and file an appeal. Next is if the court has passed an order whereby it has imposed a fine or directed arrest or detention in civil prison, in that case also such order will be appealable. But if such order has been passed for the execution of the decree, which we have already studied, that for the purposes of execution of decree, orders directing the arrest or detention of a person can also be made when the person is trying to dispose of the property or is trying to abscond or it's trying to remove the property from the local limits of the court, then in that case such an order can be made. So whenever such an order has been made in pursuance for execution of a decree, then in that case such order is not appealable. Lastly, if any order has been made under rules from which an appeal is expressly allowed by rules, meaning thereby it talks about order 43 rule 1, which provides a list of 18 orders against which an appeal can lie. Next, moving. Now, how do we read section 104 clause 2? When you are going to read section 104 clause 2, you will find that it says that no appeal shall lie against an order which has been passed in appeal. Okay? So how will you study this? Let's just take an example. Let's say that there is a trial court which has passed an order. Okay? Now, the party who is aggrieved by the order of the trial court goes to the appellate court and challenges such order. Now, upon challenging it, the appellate court passes another order. Now, against such order of the appellate court, no further appeal is going to be entertained by virtue of section 104 clause 2. Let's just read. It says that if appellate court, while dealing with an appeal under section 104 clause 1, read with order 43 rule 1, passes an order, and if such order is covered by the provisions of order 43 rule 1, then no further appeal will lie by virtue of the bar that has been created by section 104 clause 2. Let's just take an example and let's just say that under order 7 rule 10, an order has been passed by the court whereby it has returned a plaint for presentation to the proper court. Right now, the person who is aggrieved by such order has gone and filed an appeal. How come he has filed an appeal? Because it has been allowed by order 43 rule 1 subclause A. Okay, now in the appeal, the appellate court has remanded the case under order 41 rule 23. Now, as per section 104 clause 2, no further appeal is going to lie from such order of the appellate court. Okay, another example would be that if an order of the appellate court has set aside an ex parte decree, then no further appeal is going to lie against such order of the appellate court. So further we can say that section 104 clause 2 does not bar letters patent appeal. It can be understood by an example. Let's just say that if a single judge of the High Court has decided or has passed an order, and that order has been covered under section 104 clause 1, then as per section 104 clause 2, no further appeal is going to be entertained. Why? Because here the single judge has exercised its appellate jurisdiction while passing such an order. But if in the same case the single judge of the High Court was entertaining the has passed the order in exercise of its original jurisdiction, then in that case appeal would have lied to the division bench of the High Court. Example being, let's just say that if an order has been passed under order 39, which talks about temporary injunction and interlocutory orders, or under order 40, appointment of receiver, and this order has been passed by a single judge of the High Court in appeal, then under section 104 clause 2 a letters patent appeal would not have been entertained or would not lie. But if the judgment of the single judge of the High Court is in the exercise of its original civil jurisdiction, then under clause 15 of the letters patent an appeal would lie to the division bench. Next is order 43 rule 1. It provides for 18 orders from which an appeal may lie. So you can just go and read the provision. Since it is not possible for me to list all the 18 orders that have been provided under order 43 rule 1 clause A to W, I have mentioned few points. First is that if a court has passed an order whereby it has returned the plaint for presentation to the proper court, such order is appealable. Next, if court by an order has set aside or has refused to set aside a sale, that order will also be appealable. Next is an order whereby the court has rejected a permission to sue as an indigent person, that order will also be appealable. After that, an order rejecting an application to set aside dismissal of a suit for default. We have studied that if plaintiff does not appear, then the court may dismiss the suit for default. Now, if the plaintiff has applied for setting aside such dismissal of suit and that application has been rejected, then that order is also appealable. Similarly, if defendant does not show up, then the court may pass an ex parte decree. Now, if the defendant has applied for setting aside such an ex parte decree and the court has rejected an application of the defendant, such order will also be appealable. Now, for more details, you can refer to order 43 rule 1. Just understand one point, that in this slide, in the second last point, the half bracket is actually order 9 rule 9, and in the last point it is order 9 rule 13, and for more details please refer to order 43 rule 1. Now moving on to the next. Now, it is very important to understand that, okay, we know that appeal against an order is going to lie, but where are we going to file an appeal against such order? This is provided under section 106, which says that appeal from orders is going to lie in the court to which appeal would lie from decree in the suit in which the order is made. Meaning thereby, let's just say that a decree has been passed by the trial court. Now, if you want to file an appeal against the decree, you will move to the immediate superior court. Okay. Now that immediate superior court will also be the appropriate forum for filing of appeal against the order which was passed in the suit. Right. Now, if the order has been passed by a court while exercising an appellate jurisdiction, then in that case the appeal is going to lie to the High Court, lie before the High Court. Now, we have already started that in certain circumstances letters patent appeal is also maintainable, and when it is maintainable when a single judge of the High Court exercises original jurisdiction and makes an order. Then in that case an appeal will lie to the division bench under letters patent. But if the single judge passed an order in exercise of its appellate jurisdiction, then letters patent would not have been maintainable. Now, next, coming to the limitation period. So limitation period for the purposes of filing appeal against an order is 90 days from the date of order in case of appeal to the High Court, and it is 30 days in case of appeal to any other court. Now, coming to section 105. 105 basically talks about interlocutory order. Okay, and it talks about both appealable and non-appealable interlocutory order, and it basically provides a general principle, and it says that if an order is appealable, then it is not necessary or the parties are not bound to appeal against every such order. Rather, what the party can do is it can attack such order in an appeal from the final decree. As in, when the final decree has been passed, and if you are referring appeal against such decree in the memorandum of appeal, you can also mention such order which you want to challenge, and this is allowed by section 105. So section 105 says that every order, whether appealable or not, except an order for remand, which is covered under section 105 clause 2, such order can be attacked in an appeal from the final decree on two grounds. First is that the order is erroneous, or there is defect, or there is irregularity in the order, or and such error, defect or irregularity affects the decision of the case. So basically there are two things. First is, if the order is appealable, then the party is not bound to just go and file appeal against such appealable orders. What it can do is, it can just mention it as a ground of objection in the memorandum of appeal against the final decree. Okay, now why it has been done? It has been done in order to avoid unnecessary harassment with endless expense and delay, which might be caused by multiple filing of appeal against multiple orders that are passed in a suit. And we all know that there are many orders, there are n number of orders that can be passed in a particular suit. Now, if you're going to if you're going to appeal against every order that has been passed, provided it is of appealable nature, then it is going to cause expense and delay to both the parties. Now next is that section 105 also talks about non-appealable orders, and it says that if the interlocutory order is such against which no appeal lies, then in that case also you can always point out the error, defect or irregularity in that non-appealable order, and you can take it as a ground of objection in the memorandum of appeal when you are going to prefer an appeal from the final decree that has. Okay, so next is section 105 clause 1. It uses three words: error, defect or irregularity. So this error, defect or irregularity must be in matters of law and procedure, since we are not concerned about error, defect or irregularity in matters of fact. Now other words that have been used is affecting the decision of the case. It means that affecting the decision of the case on its merits. Okay, now these two conditions are necessary to be fulfilled if you want to take recourse of section 105. An example can be taken if an order has been passed under order 9 rule 13, and by such order an ex parte decree has been set aside. Now such an order is not an order that affects the merits of the case, but such order merely ensures a hearing upon the merits. Therefore, you cannot challenge such order, or you cannot attack such order in an appeal from the decree in the suit. Next, there may be certain orders passed of wherein certain documents are accepted or rejected. Now these orders accepting or rejecting a document are also not appealable, but when you are challenging the correctness, validity and propriety of a particular document, then it can very well be made a ground of objection in the memorandum of appeal while preferring an appeal against the final decree to the appellate court, and you can take recourse of the section 105 of the civil procedure code. Now next is, if an application has been made under order 9 rule 7, which talks about a defendant putting forth a good cause for setting aside ex parte order, and then also the application has not been accepted but it has been dismissed, then in that case the defendant can take this ground in the appeal from the final decree. And last is section 105 clause 2. It talks about order of remand, and it says that if an order of remand is appealable, then then appeal against such order must be made directly, because if you are going to avoid it, then at the later stage you will be precluded from disputing its correctness. And this way section 105 clause 2 is different from what has been laid down in section 105 clause 1. And with reference to section 105 clause 1, we need to see one case, and that is Satyadhan versus Deo Rajan Devi. It talks about the application of principle of res judicata and when it is applicable, because see, when an order is appealable and you are not appealing against such order then and there, and you are waiting for the final decree, and after that you are including the error, irregularity of that order in the memorandum of appeal, then whether it is barred by principle of res judicata or not, this was laid down in the case of Satyadhan versus Devarajan Devi. In this case, the Supreme Court has held that though the principles of res judicata will apply to different stages of same litigation, it does not preclude a party from questioning the correctness of an interlocutory order in an appeal against the decree, except where it falls under section 105 clause 2. We talk about procedure at hearing. So the provisions that apply to first appeal will also be applicable to appeal from orders. You can refer to order 43 rule 2 and section 108. Next, you need to understand that when we studied about the bar that has been created by section 104 clause 2 regarding appeal against orders which has been passed in appeal, it is not going to apply in case of appeal to Supreme Court. A person can file an appeal to the Supreme Court, and section 104 clause 2, that bar will not be applicable in this context. Now lastly, we will talk about the powers of the appellate court. The powers of the appellate court has been provided under section 107, and it says that appellate court has power to determine a case finally. You can refer to order 41, rule 32 and 33. Next is it has the power to remand a case, meaning thereby it has the power to send back the case to the lower court under order 41, rule 23. Next is it can also frame issues and refer them for trial under order 41, rule 25. And lastly, it can take additional evidence or require such evidence to be taken, order 41, rule 27. We studied that with regard to this, such power lies with the first appellate court only, but in certain circumstances High Court, while entertaining second appeal, can also take additional evidence. We have studied those grounds in the previous lecture. Okay, so as far as appeals from orders are concerned, this is it, and I'll soon make another videos regarding appeals to Supreme Court. So as far as this is concerned, this is it. Thank you so much for listening to me, and take care, students.